As a new client of Safe Hiring Solutions, we want to spend a couple minutes just giving you a little more information on some of the legal requirements you will now be required to follow when you're using a third party such as Safe Hiring Solutions to conduct your background screening. So we'll talk just briefly about the EEOC, and then we'll talk about the Federal Fair Credit Reporting Act. The EEOC strongly discourages the use of any kind of blanket policy to deny somebody an employment position just because of a criminal conviction. A criminal conviction alone should not be the cause for denying employment. They would like you to use a three-pronged approach where you basically look at the nature of the crime, what is the job or position the applicant is seeking, and how much time has passed since the conviction or the completion of the sentence, so that you can articulate how that particular crime or criminal conviction would impact the position that they're seeking with your organization. The Federal Fair Credit Reporting Act also requires, even though the law references credit, the Fair Credit Reporting Act applies to any kind of background screening where you're using a third party such as Safe Hiring Solutions to conduct your background screening. The first step under the Fair Credit Reporting Act that you're required to use on every single applicant for employment is you must give them a disclosure statement where you're describing what they are going to encounter in the background check and that the applicant authorizes the background check either with pen and paper or an electronic signature. The second step only applies when you are going to deny somebody an employment position based in whole or part on the background screening report. In whole would basically be a criminal conviction, and that particular conviction would not allow them to be employed in your organization. In part would be they've been convicted of a crime. The crime itself maybe would not preclude them from being employed, but they didn't disclose it on their application, so you're going to deny the position based on dishonesty. So it was based in part on the criminal background screening report. So if it's based at all on the background screening report, the first step is you're required to send a pre-adverse action letter that describes to the applicant that conditional offer that you may be impacted by a criminal background screening report. You must include a copy of the report so they have a right to see what's going to be used against them, and you need to include a summary of their rights under the Fair Credit Reporting Act. Safe Hiring Solutions will supply all of these for you at no additional cost. After a reasonable amount of time, generally interpreted as at least 5 business days, you would send an adverse action letter, or basically an employment denial letter. I would recommend sending the pre-adverse action letter and package certified mail so you can document that you've actually done this, and then you would send the adverse action letter 5 business days later. If the employee or applicant for employment disputes any part of the report, Safe Hiring Solutions would notify you immediately that they're disputing the report, and if we need to initiate further investigation, we would do that and then would notify you either changes in the report or that the report remains the same. A couple of the reporting limitations under the Fair Credit Reporting Act: there are no restrictions on criminal convictions, but the Fair Credit Reporting Act does restrict the reporting of arrest data to 7 years unless the salary of the position exceeds $75,000. So any case where it's an arrest only, pretrial diversion, dismissal is going to be restricted to 7 years unless the salary exceeds $75,000. Individual states may further limit reporting of criminal records. If you have any questions, just contact Safe Hiring Solutions or your individual client services manager. Have a great day.